The number of Ugandans languishing in jail without trial continues to rise. Among them are several political figures and opposition supporters, many of whom have had their bail applications repeatedly denied, raising questions about access to justice and judicial independence. The recent case of opposition leader Dr. Kizza Besigye and his colleague Obed Lutale, abducted from Kenya in November 2024 and detained by the court-martial, has drawn international concern. In a statement released on Wednesday, the Office of the United Nations Human Rights High Commissioner raised concerns over repeated bail denials for Besigye and Lutale as seriously troubling. UN Human Rights Office spokesperson Les Throzo delivered the statement urging the Ugandan authorities to reconsider the decision to deny the two bail on the 8th of August and ensure that any legal proceedings against them are fully in line with international human rights law. The United Nations isn't alone. Human rights lawyer Aaron Kizza, himself once convicted by the court-martial, says the continued denial of bail lacks legal justification, especially after the Supreme Court's January 2025 ruling that declared the military court illegal.
Article 23, Clause 6, Paragraph C is so clear that if you spend 6 months before you are committed to High Court for trial, you are entitled to mandatory bail, not discretionary bail. The only job of a judicial officer in mandatory bail is to set the terms of bail, such as the reporting period, if they want to charge some bond money, the money and the sureties. It's not part of the judicial function to exercise whether or not to grant a person who has spent more than 6 months in custody, whether to give them bail or not. So Justice Emmanuel Waguma got the law wrong, got the math wrong, and got the logic wrong.
Despite the Supreme Court ordering a transfer of all court-martial cases to civilian courts, many, including supporters of the National Unity Platform detained since 2020, remain in military custody.
The Supreme Court provided no framework for the transfer of those civilians to civilian courts. Neither did it provide for a procedure. Because if it had provided for a procedure, then somebody would challenge the delay to implement that procedure. So the Supreme Court created a lacuna.
Opposition leaders like Lord Mayor Erias Lukwago believe the judiciary is under siege from the executive.
Museveni is on record, as was delivering his New Year message, that he had spoken to Justice Owiny-Dollo in regards to issues of granting bail to people who are on political charges, those who are faced with granting bail to political prisoners, that he was very bitter with that. Museveni said he took exception to that, and he had spoken to Justice Owiny-Dollo. And indeed, the results of that conversation are witnessed today. The right to bail, the right to mandatory bail has now totally been eroded, completely eroded. So today, a judge can can boldly, and today a judge can brazenly face cameras and deliver judgment and say, I've denied you mandatory bail. Totally ridiculous.
But Chief Justice Alfonse Owiny-Dollo has strongly pushed back, dismissing such claims as nonsense and calling on the public to instead focus on systemic reforms within the judiciary.
I see even lawyers now say, blaming courts for not granting bail to so and so. That is total nonsense. Somebody has exercised a discretion. By the way, the judicial officer can even be plainly wrong.
The state in its affidavit in reply agreed that Besigye indeed had been the subject of court-martial proceedings. So the evidence was before the judge. The judge ignored that evidence to refuse to grant Besigye mandatory bail. So this was a case of improper exercise of discretion by the judge. Unfortunately, it's not even subject to review, it's not subject to appeal. He has to apply again. So the problem is not with the law of bail. The problem is with the judicial officers who are ignoring and subverting the law.
Do you know how many judicial officers I have? Slightly over 400 for 45 million people. We have less than 100 judges, then about 300 and something magistrates. So what we need to do as Ugandans, you want to create new constituencies, you want this and this, fight so that we have sufficient judicial officers.
Critics, however, say the judiciary is setting a dangerous precedent.
The trend is very clear. If you are involved in politics, not of NRM, it's hard to get out, and the judiciary is not willing to be the guarantors and the bastions of freedom that they were created by the Constitution to be, and that they are paid every month to be.
They were denied the bail in the general court martial, you have done the same. They were denied the fair hearing, you have not accorded them the same. So, where is the difference, Mr. Justice Owiny-Dollo?
Meanwhile, President Yoweri Museveni has repeatedly urged that bail be denied for certain offences ranging from corruption to terrorism and politically motivated violence.
And it's unfortunate that rather than stand up for judicial independence, rather than stand up for rule of law, rather than stand up for liberty, which is honor next to life, they are choosing political expediency.
As these tensions persist, the rule of law and human rights in Uganda remain under sharp scrutiny for many behind bars, especially those without trial. The line between justice and persecution is growing even thinner. Walter Mwesije, NTV.
Because the more you cry, the more you people continue to die. So rise and defend your rights.